Good morning, Your Honors.
Good morning.
I believe it should be Mr. Snelson is the other attorney on this. So I just want to make sure.
That appears to be the case, yes.
All right, may it please the court. Andrew Labby on behalf of Meritus and Sunstone Construction. I would like to reserve 5 minutes for rebuttal, please.
All right, thank you.
Your Honors, the appellants are seeking a reversal of summary judgment that was granted in favor of the structures group below due to various errors committed by the trial court. The first issue, Your Honor, is that prior to summary judgment being granted, the appellants were seeking leave to amend their complaint against the structures group. Essentially, Your Honors, this is a complex construction defect case that involved numerous parties. The structures group was initially brought in after an email was discovered between the structures group and another third-party defendant regarding the insulated wall panels that were installed. And it was believed at the time of the original third-party complaint that related to the structures group that was the extent of their involvement. Later on through discovery, it was learned that they were actually hired directly by Sunstone to provide additional engineering services. It was also discovered that they had signed and sealed various plans.
They had their logo on a few plans. Did they actually seal them?
Yes, Your Honor. I believe that they signed and sealed 4 different plans, and their logo appeared on a number of different sheets as well.
Help me out on a preliminary point. Is there any dispute that this was a design build contract that the contractors had with the owners?
I don't believe so, Your Honor, no.
There's no dispute that is the case?
Not that I'm aware of. It was not an issue on summary judgment, at least with the structures group.
Well, that dovetails into where I'm going with this, which is what is the theory? And unfortunately, I can't seem to pull up my record right now, but what is the theory in the proposed third amended third-party complaint? What is the theory of recovery against these engineers that you believe that the trial court did not allow you to present?
Yes, Your Honor.
Given that it was a design build contract with the owners.
Your Honor, the third amended, or the proposed third amended third-party complaint, excuse me. Yeah. So it alleged an additional count of breach of contract that was not in the initial second amended third-party complaint. Okay,
great. What was the theory, but what was the anchor theory? In order to progress with a third-party complaint, in order to be able to, you have to have an anchor claim of either indemnity, contribution, or subrogation. What was the flag claim for the third amended third-party complaint?
Indemnification, Your Honor.
And under what theory, if it's a design build contract with the owner? I know this is kind of like broader issue, but it does. How is the engineer ever going to be wholly at fault if it's a design build contract with the owner?
Your Honor, and I suppose I should have, when I said that I'm not aware of any issues related to whether or not it was a design build contract. I was not trial counsel.
Right.
Focused on the issues on appeal.
That's a pretty big underlying issue for purposes of ferreting out whether or not a common law indemnification claim, whether that dog would hunt, right? Because if it's a design build contract, I'm trying to think what that would look like. How would that work? Unless the engineers had like their own side contract directly with the owners, maybe, but there's no allegation of that anywhere. So help me out. How do you get to 100% fault, which is what common law indemnity requires? How do you get to 100% fault for these third-party defendants when they are not in privity and contract with the owner and the GC has a design build contract with the owners? How do we get there?
Your Honor, so what the allegations in the third amended complaint are that TSG was retained to provide structural engineering services.
Retained by who?
Well, they were retained by Sunstone /
contractors.
But also they were retained by another third-party defending Grammatico, or at least they provided services to
For
Grammatico.
purposes of indemnity, why does that matter? Because indemnity, well, you know how this works. Indemnity only arises if as a derivative form of liability. The GC has to be liable to the owners, but for the entire fault of that liability falling with a third-party defendant, there would be indemnity. But I'm trying to figure out, how does that work in your theory here?
Well, Your Honor, so a portion of the damages that were being alleged by the plaintiff in the case below were related to, for example, the installation of these SIPS panels.
Right?
And the allegation in the third amended complaint is that TSG provided structural services and performed those negligently, and but for that negligent performance of those services.
Okay, so you've apportioned out part of the damages, that is an apportionment of liability, which is not common law indemnity as a matter of law. It can't be. It might be a form of comparative negligence. It might be a form of comparative fault. It might be a form of third-party liability under breach of contract. But to get that anchor claim of common law indemnity, it has to be the entire fault was because of this engineer for all of the plaintiff's claims. And I, as the GC, would not have had to pay this money to the owners were it not for the entirety of this fault. Right? That's my understanding of how common law indemnity works.
Your Honor, so common law indemnity, there has to be no fault on the part of,
right.
And that is what was alleged in the third amended complaint, was that there was no fault on the part of Sunstone Emeritus, and that TSG performed their services negligently, which, sorry, I didn't mean.
You've got that allegation, so that gets you past the motion to dismiss. But we're now here on summary judgment, and we've got the record evidence in front of us. Under what theory of the record facts that were put before the trial judge could the trial judge have said, yeah, there's a disputed fact here for a jury to sort out whether common law indemnity, 100% fault, would lie with these engineering design professionals?
Yes, Your Honor. Well, we filed an expert affidavit that outlined that TSG was more likely than not a cause of the damages sought by plaintiff. And it outlined all the services that they provided, that they signed and sealed plans, again, that their logo appeared on various sheets. So there was certainly at least a genuine issue of material fact, viewing everything in the light most favorable to appellants as to whether or not the common law indemnification claim should have survived summary judgment. So if that answers your question, I'll.
I have a couple.
That's what you got. All right.
I have a couple of procedural questions, because it doesn't appear that the motion for leave to amend was set for the same day as the summary judgment, was it?
I believe it was set for the same day.
Okay, because I'm trying to figure out why Mr. Ross didn't want to argue it, because he said on the record, I don't want to argue the motion to leave to amend. But secondly, you make reference to a motion to compel the corporate representative of the architect, Architronics or something. Was that, I don't know that you made it clear to Judge Huey whether that particular deposition would have revealed or demonstrated some type of material issue of fact, because the basis of your argument is there's pending discovery's incomplete. But how did you articulate that to Judge Huey here?
Yes, Your Honor. So I'll answer your first question regarding the motion for leave to amend. So I believe it was set. It was decided on that day. I'm not sure what portion of the record you're referencing, so I can't
find notices of hearing.
But the motion for leave was also set 4 months after the cutoff date in the case management order, wasn't it?
It was after the case management. So the case management order was entered. Then the parties filed a joint motion to extend the deadlines. And subsequently, a new trial order was entered that extended the deadline for filing of all motions. It didn't specify as far as amendments. And actually, the amended complaint that brought TSG into the case to begin with was actually after that original cutoff date. But Your Honor, so sorry, Judge Sleet, to get back to your question. So the motion for leave to amend was decided on that day. It was
I just didn't know if it was set for hearing. So it is. That's fine.
Yes, Your Honor.
But, okay, so you had a motion to compel that was pending.
Yes, Your
Compel
Honor.
the corporate rep's deposition of Archatronics.
Our-
What is it about that particular deposition that made summary judgment premature? I didn't see that articulated at the hearing.
Yes, Your Honor. I believe it was raised at least briefly at the hearing, and then when we filed a motion for rehearing, it might have been set out a little further.
Okay.
But and I apologize, Your Honor, I believe it's Architectonics,
Okay.
name of the company, but they were the architect of record. A portion of the services that TSG was retained to provide was a review of those plans and to sign off on those plans. And also, as outlined in the brief, there was just a lot of confusion as to what TSG's role was because their logo appeared on various pages. TSG wasn't really sure why so it wasn't clear who the engineer of record was. And it was believed that the architect was going to be able to provide some further information on that because that was still a remaining issue.
Gotta be honest, I've never run into that as an issue in construction litigation before where we're not sure who the engineer of record is.
Your Honor, I agree with you wholeheartedly.
But your client's the general contractor. How does that happen? Your client selects the professionals under a design build contract. How does that happen?
Your Honor, I couldn't say. I believe so. Sunstone was dissolved in 2014, and there were issues with getting information from them was a problem. I will say that, so the plaintiff's expert testified that, it was not clear from the evidence that he had at the time of his deposition, which was in January 2019, who the engineer of record was or whether there was one. Or whether, I believe what he said was there's an engineer of record, even if it was the architect of record, that they would have served as the engineer of record. So that's another relevant portion of testimony that the architect could have provided.
Wasn't there also an issue in this case about whether some of the advice that the engineers provided on this particular issue of importance wasn't even followed?
Yes, Your Honor. So there was an issue with one of the third-party defendants who had a separate I'll call it a contractual relationship. They had a separate relationship with TSG regarding installation of the wall panels. And there was testimony provided that that third-party defendant, Grammatica, did not follow TSG's advice. But there's also, the affidavit filed by our expert was that it was incumbent on TSG to supervise as well to ensure that its recommendations were followed, especially when it's signing and sealing plans or potentially signing and sealing plans. Again, we still don't know the full extent. So, that's another issue as well that could have led to liability. Just to circle back briefly to the failure to allow to leave to amend, I just want to make sure I get it out that, the trial court did not express any legal basis for denying leave to amend or for granting summary judgment with prejudice. He did not determine that it was prejudicial, that the privilege had been abused, or that the amendment would have been futile, which is this court has held, Grover versus Carl and Gear versus Jacobson, that's a requirement of the law that you have to make that kind of finding, and that in and of itself, I believe, constitutes reversible error. And again, we kind of addressed it anyway. I don't believe that the amendment would have been futile. The privilege hadn't been abused.
Well, you've heard Judge Lucas's, all of his questions to you would strongly suggest that the amendment would be futile. So it's hard for you to kind of, with a straight face, make that argument today. He's asked you some very pointed questions about their ability to even connect this cause of action up.
Yes, Your Honor. And again, I believe so. Again, if you're looking in the light most favorable to the appellants at the summary judgment stage, based on the evidence that we had, and again, discovery was ongoing, it hadn't been closed, but we have our experts saying that TSG was potentially an engineer of record, that they signed and sealed documents, that they performed these.
Potentially an engineer of record. You did that well without smiling. Either they were or they weren't, right? How do you not know that in a project of this scope?
I don't disagree, Your Honor. Even the TSG's corporate representative, though, at deposition couldn't explain why their logo appeared on the amount of sheets and then the plans that it did. So, there was some uncertainty there that I think, unfortunately, could have been cleared up very easily had we been permitted to depose.
I mean, like, if you're getting into, well, we could have cleared this up, we could have cleared this up. I mean, the most logical procedural way for you all to pursue this is just file an independent action against these folks. And if you really believe it's all got to travel together, then you consolidate it together. And that gets you out of the whole third-party complaint, the strictures of the rule about what you can and can't plead in that. You can plead whatever in good faith you can plead against these design professionals as an independent cause of action, but that's not the route you all chose.
And we're at 15 minutes, just so everybody knows, and it's your time, sir. You may use it however you want to.
I'll just briefly respond to Judge Lucas and then reserve the rest of my time. Your Honor, yes, that was an option that could have been pursued. It's not what was pursued in this case, and I don't think potentially having that other avenue, I don't think impacts the errors that the trial court committed in granting summary.
Fair enough.
Okay. Thank you.
Good morning. May it please the court. My name is Mark Snelson. I represent the appellee, the Structures Group, who was a third-party defendant below. I may refer to the Structures Group as TSG. TSG is a structural engineering firm located in Tampa, Florida. Judges, this appeal breaks out into three main issues. The first is, we heard a lot about the third amended third-party complaint, but the pleading that was operative at the summary judgment hearing was the second amended third-party complaint. In the case law, the Hart Properties case out of the Supreme Court from decades ago and its progeny make it clear that I'm entitled to have my summary judgment heard based upon the claims that are before the court in the operative pleading at the time. And with respect to the second amended third-party complaint, it's crystal clear from reviewing that complaint, and it's crystal clear by an admission in the appellant's initial brief in this case, that the entire theory of recovery against the Structures Group in the second amended third-party complaint was based upon the threshold contention that my client reviewed and approved shop drawings for the SIP panels that were ultimately installed on the project. At summary judgment, the record was crystal clear. There was undisputed testimony from my client that said, not only was it not in my contract to review shop drawings, no one sent me any shop drawings. No one asked me to review any shop drawings, and just flat out, we didn't review any shop drawings. No evidence to dispute that. And again, all of the claims in the second amended third-party complaint were based upon that threshold contention that my client did in fact review shop drawings. It was just, we had three motions for summary judgment, all of which were granted. This goes to that first motion for summary judgment. It was simply a no evidence motion. I've heard trial judges refer to it as a where's the beef motion. They alleged we did A. The undisputed material facts in the record showed we did not do A. So for that reason, and we didn't even hear any argument from appellants this morning, nor actually in their argument before the trial court, that there was some evidence that my client reviewed shop drawings. And you turn now, so that's the first issue, whether the trial court was correct in granting summary judgment based upon the operative pleading at the time of the hearing, the second amended third-party complaint. And I don't hear much argument from appellants that that was a problem. What I hear more of, and what their brief focused more on, and therefore what I'll focus more on, are the two additional main issues in the case. Number one is, was the trial court within its discretion to enter summary judgment even though there were 21 days left in the discovery period? And then the third issue is, did the trial court have the discretion to deny their motion for leave to file the third amended third-party complaint? So let me talk about the additional discovery. I want to make one thing clear, and what differentiates our case from the UFFDAA and the SICA cases that the appellants rely upon. At the time of the summary judgment hearing, there was no discovery that was actually pending. Any discovery to my client had already been responded to, and the architect's deposition was not even a given. As the court noted, there was a motion to compel related to that deposition that was set for the same day. So at the time of the summary judgment hearing, which again was 21 days before the discovery deadline, there was no pending discovery. Now,
which party moved to compel that deposition?
I believe the appellants moved to compel the deposition of the architect. Again, I
Okay.
didn't have a dog in that fight.
All right, well, help me reconcile this, because if Mr. Ross below for the appellant argues, Judge, I need to take this deposition and inquire and find out some information of this particular person, but yet his amended complaint is denied and summary judgment's granted against him, but Judge Huey grants the motion to compel the deposition that Mr. Ross was seeking. Help me reconcile that.
Well, sure. Mr. Ross, I believe, was seeking the deposition, not just as a potential way to get around my motions, but he needed the architect's deposition for his own purposes, considering he had pled, the same type of third-party claims against me, he pled against the architect. So he had to establish his record. What I'll say with respect to the trial court's decision to move forward with summary judgment, despite the, like I said, 3 more weeks of discovery, it's an abuse of discretion standard. The Colby case out of the 2nd DCA, the Martins case out of the 5th DCA, the Crespo case out of the 3rd DCA, all of the DCAs talk about how it's a matter of discretion. And as Judge Morris pointed out, and some of the arguments I heard in the other cases this morning, that standard is judged under the reasonable judge standard. If any reasonable judge would have done what this judge did, then you can't overturn it. And here, Judge Huey was reasonable for moving forward with summary judgment for 2 reasons. The first is that the appellants, as Judge Lucas pointed out, the appellants here hired everyone for this job, both the construction side trades and the architect and the engineer. There should be no confusion to them over which company played which role, considering they hired everyone and gave everyone their respective scopes of work. Nonetheless, to the extent there was really some confusion on the appellant's end in that regard, I would point out that they had exactly, to the day, 2 years and 7 months from the commencement of the case to the summary judgment hearing to take whatever discovery they wanted to. With respect to the architect, Mr. Ross specifically argued to the trial court that he had put the architect on notice, the architect and its insurance carrier on notice, prior to the mediation of this case in August of 2018. So well before even bringing the architect into the case, they had put the architect on notice, which showed that they knew the architect was out there, had some potential liability, and they could have sought this discovery from the architect at any time, whether as a non-party, through a non-party subpoena, non-party deposition, or once they brought them into this case. Again, this is not a case where the summary judgment was granted early in the proceedings or with an underdeveloped or limited record. The summary judgment hearing, the motion for leave to amend hearing, was 21 days before the discovery deadline and 60 days before trial. And this was a trial court that was adamant that this case was going to trial in early June as scheduled. They had 2 years and 7 months to do whatever discovery they wanted to do. And in that regard, this case is very similar to the Colby case out of the 2nd DCA. In that case, the summary judgment hearing was 18 days before the discovery deadline. Ours, like I said, was 21. And in Colby, the opinion held that the non-movement does not have an unlimited right to discovery prior to summary judgment. And the 2nd DCA specifically relied on the fact that the non-movement in that case had 3 years to do discovery to create whatever record he wanted to create. Here, we've got almost 3 years, 2 years and 7 months. So I'd say that any missing discovery at the time of the summary judgment hearing was due to the non-movements, the appellant's lack of diligence. And the case law says that that's one of the reasons the judge can exercise his discretion to move forward with summary judgment, even though there may be some time remaining for discovery. The second reason I would argue that moving forward with summary judgment, despite additional discovery, was within the trial court's discretion, was because, as Judge Lucas alluded to, the architect's deposition would not have changed the outcome of my client's second motion for summary judgment. That second motion for summary judgment was directed at the common law indemnity count. How can a general contractor who hires every trade, every construction side trade, every design professional under his contractual umbrella for the job ever be wholly without fault for proven construction defects? Again, this is a third-party complaint, so the claims against my client don't spring forward unless and until there's been some finding that the plaintiff proved its defect claims. And appellants, as the general contractors, have the duty per case law and per statute to oversee the work of their subs. They're the ones that pull the permits. They can't let the subs do whatever they want to do on this job. They have to manage the work of the subs. They have to ensure that their subs are performing their work properly. And based upon this record, if construction defects are proven, the general contractor has the primary liability to the owner or to the association in this regard, because it has to answer for the fault of all of its subs. In addition to that kind of general idea about a general contractor who pulls the permit could never logically be wholly without fault for construction defects, there's also this, and it's related to a particular defect claim related to the installation of these SIP panels at the two end unit stairwells, interior stairwells. It was a condition, a construction defect of which the plaintiff complained. And there was a requirement in the plans, the permanent set of plans by the city of Tampa, which the appellants were required to abide by. There was a requirement that said, you have to provide signed and sealed shop drawings for these SIP panels that show the anchorage and the layout and how you're going to install these things throughout the project. And the plaintiff's expert gave undisputed testimony that that requirement of the permitted set of plans falls primarily to the general contractor. Well, the general contractor admitted below in defending against another company's motion for summary judgment that it never procured any signed and sealed shop drawings for the SIPs. And the undisputed testimony in the record through the plaintiff's expert was that those shop drawings would have detailed the condition, the installation as it should have been in those two end unit stairwells, which again was a condition of which the plaintiff complained and sought damages. So again, whether or not to move forward with summary judgment, even though there may be time left for additional discovery, it's an abuse of discretion standard. It's the reasonable judge standard, as Judge Morris articulated earlier this morning. And for those two main reasons, a lack of diligence, plenty of time to have done discovery, and because it wouldn't have changed the outcome of the second motion for summary judgment, I would argue that Judge Huey was within his discretion to move forward, even though there were 21 days left on the discovery deadline. Unless there are any questions about this additional discovery issue, I'll move on to the denial of the motion for leave. So trial court here had the discretion to deny the appellant's motion for leave to file a third amended third-party complaint for three separate reasons, each of which would be sufficient in and of itself for a denial of the motion, but especially when taken together, it's evident that the trial court
How would your client have been prejudiced by the amendment?
Sure, Judge. Two ways. Number one, as I mentioned, the motion was filed just 21 days before the discovery deadline. This trial court was adamant that the case was going to
Now, was that the discovery deadline that the parties had stipulated to extend, or was that the original deadline?
No, Judge. This was the last iteration of the court's trial order.
Okay.
Set the discovery deadline, I believe, for April 30 or May 1. Regardless, as of the date of the motion for leave hearing, the summary judgment hearing, there were 21 days left in that discovery deadline.
But at least it was before the deadline and not after.
It was before the deadline, Your Honor, but not even enough time to get out a set of written discovery to get it responded to. And the prejudice due to the timing it is in and of itself sufficient under the Toscano case. But
well, hang on, though. Let's focus on the 21 days before the deadline. So 21 days is not enough time. How about 40 days? Is that enough time?
I would say no, Judge.
Yeah, do you see where I'm going with this?
I do.
I mean, we have a deadline, and now we're saying there's a certain time frame before a deadline. That's unacceptable, which is a very vague sort of situation. So help me. If we're saying the deadline isn't not what matters, it's how much time before the deadline matters. Tell me how much time would have been okay.
I'll do my best, Judge. And it kind of plays into the second point, where not only was this a very late motion, both by the terms of the agreed order, it was an agreed deadline that appellants agreed to, an agreed case management order that said your deadline is, I believe it was sometime in November or December of 2019 for these motions, yet they didn't file theirs until 5 months later. So not only that, we're up against the discovery deadline, but that's all compounded by the fact that we are going from the second amended third-party complaint, which was TSG, you reviewed shop drawings, and that's it. And that's for the months that I was in the case, that's all my discovery and my motion practice was focused on.
So you're basically saying they've abused the privilege at this point?
I'm not saying they've abused the privilege. I'm saying what they wanted to assert in their third amended third-party complaint completely changed the theory of recovery against my client, interjected all these new claims that hadn't been touched on in discovery or motion practice before. And
so that's how you were prejudiced by the late amendment?
Correct. And I've only got 21 days to try to sort through all these new claims. Again, we went from second amended third-party complaint, which is shop drawings, and that's it, to in the third amended third-party complaint, they wanted to allege that my client failed to make sure the SIPs were installed correctly during construction. Well, as the trial court pointed out, my client's undisputed role, they didn't have any construction side role. Another thing they wanted to allege was my client failed to perform wind testing. As the trial court recognized, that wasn't in my client's contract. They wanted to allege that my client should have warned somebody about using stucco over SIPs panels. Never mind the undisputed testimony that that's an architectural decision, not a structural decision. And there were several other of these new claims that hadn't been vetted at all that completely changed the theory of recovery against my client when we're 3 weeks from the discovery deadline. So that's
all of that could have been remedied by extending a deadline if the court had found that these were, material and substantial and that sort of thing. I mean, isn't that fair to say? I mean, it's just a deadline and being parties to these all the time.
I suppose everything's possible, Judge, but again, we were also faced up with trial on June 10th, and this court, as you can see in the record on several different occasions, this court said, if I've got any case that's going to trial on time, it's this one. I'm pushing this case, period. So I don't know how much leeway there was to move a lot of deadlines.
And that's in the discretion of the trial judge anyway, right?
It is, Judge.
So, all right. So you've shown me how you've been prejudiced. So how about, this is only the third amendment in a complex construction litigation case. So it doesn't sound like there's been the privilege to amend has been abused. Would you agree with that?
We have not argued that, Judge.
Okay.
We have not argued. We've argued prejudice and we've argued futility for the reasons I expressed when talking about the additional discovery and for the reasons Judge Lucas brought up in discussing common law indemnity.
Yeah, I mean, I would think that the fact that the amendment would be potentially futile or appeared to be futile, we don't know what Judge Huey was thinking, but clearly that would be a factor high in these three criteria that we have to consider, right? I mean, the futility of the amendment based on the known facts at that time.
Sure. As we know, Judge, from the decades of case law, that a judge has discretion if one of three factors are present. One is prejudice to my client. The second is whether the privilege has been abused, and that's not something we're arguing. And then the third is whether the amendment would be futile. Okay. And so we're arguing essentially 1 and 3.
Okay. That's kind of what I thought. I just wanted to be sure. Okay. Thanks.
So, Mr. Snelson, when you have a situation like this, and I can understand, we've all been there, and Judge Huey was very inquisitive, and there was a long dialogue back and forth about the intricacies of this project and everything, but he didn't really specifically articulate those three findings. But does that preclude us from affirming if the record reveals a basis?
It does not, Judge, and that's the Florida Now case out of the first DCA that I've cited in my answer brief. In the Florida Now case, the trial court didn't deny the amendment based upon futility, but the appellate court upheld the denial of the motion for leave based upon futility. And the quote was, the trial court did not specifically rely on the futility exception as a basis for dismissal. However, we have the power to affirm a trial court's ruling on any alternative basis. And I'd also say this, Judge, I agree that at the conclusion of the hearing, Judge Huey did not say, I find prejudice because, or I find this is futile because, but I will say that it was evident that he took those considerations into account in the 11 pages of hearing transcript that are devoted to this colloquy between Judge Huey and appellant's counsel about, okay, what's coming in? We're 2 months from trial. This is not supported by the facts. That's not supported by the facts. So they cite to the Greer case for the proposition that there has to be an actual written holding that I find prejudice because I don't read Greer that way. I don't see any bright line test in Greer that's like that. The Greer opinion notes that that was the situation in that case, but it doesn't lay down a bright line rule that says you have to reverse if those magic words don't appear in an order. And again, like I said, we've got ample hearing transcript where this trial judge gave appellant's counsel every opportunity to articulate a viable claim, a viable amended claim that would be logical and would make sense based upon the undisputed, a well-developed factual record after 2 years and 7 months of litigation. And as is shown in that transcript, the appellant's counsel was unable to articulate anything that would make sense and would bear some relationship to the undisputed facts concerning my client's scope of work. So I see that I'm out of time. The appellants would ask that the trial court be affirmed in all respects. Thank you.
Your timing's perfect. You're at 20 minutes. All right.
Thank you, Your Honors. So just to
You've got 4.5 minutes, just so you know.
Thank you, Your Honor. So to briefly address some of the points that were made, the first point about summary judgment being heard on the operative pleading, which we don't contest, and that kind of proves the point about the fact that it should have been without prejudice with leave to amend. And this court held in Hervey versus Alfonso that even if summary judgment is warranted as to the claim alleged, if the record indicates that the plaintiff may have a cause of action not previously pled or a better one than originally pled, that the summary judgment should be granted without prejudice and with leave to amend. And we would submit that that is the case here. And I would also disagree with the proposition that the trial court's failure to find one of those 3 reasons for denying leave to amend is not required. The Grover versus Carl case, and I'm just going to quote from it. This court held, although the trial court properly granted summary judgment on the operative pleading, it erred in denying leave to amend without determining, as our law requires, that the proposed amendment was prejudicial, an abuse of privilege, or futile. So it's saying the law requires you to make such a finding. And it was the same thing in Geer. The court wasn't saying that they disagreed with the denial of leave to amend. The court reversed because there was not one of those 3 reasons. There wasn't a finding that one of those 3 reasons existed. And in this case, I don't think that the trial court, I think an objective reading of that transcript, the trial court didn't give consideration to any of those factors when considering the leave to amend. It was really kind of, the hearing was kind of jumbled, and it went from a discussion of TSG's belated discovery responses straight into the trial court saying, we're not amending. I don't believe that that's sufficient, even if this court could consider those 3 factors. I don't believe that the trial court's comments at the hearing show that he even considered it. So I do believe that reversal is appropriate. Also, counsel stated that no discovery was pending, and we've already addressed the architect's deposition, which again, I would say that that does qualify as outstanding discovery. We had requested deposition. We had sought to compel a deposition. It was granted the same day, albeit after the motion for summary judgment. But there's also an issue with TSG's discovery responses. We served a request for production in February 2019. They responded to the discovery 2 business days. They produced the documents 2 business days prior to the hearing. And this did come up before the trial court at the motion for summary judgment hearing. And counsel explained that he had not had an adequate opportunity to review those documents, and he had had no opportunity to review them with an expert. And the trial court essentially completely discounted it and said, it doesn't, I don't care when you got them, tell me what it says, is essentially what he said. I'm paraphrasing. And I don't believe that that's appropriate. I don't believe that obviously goes against the spirit of the rule regarding outstanding discovery. If you hand your discovery responses outside the courtroom as you're walking into the hearing, technically that discovery is not outstanding anymore, but it doesn't mean that the party had an opportunity to evaluate it. So I do believe that that is another basis, the failure to timely respond, or at least to give we should have been given an opportunity. I don't agree with the assertion, the case had been pending for 2 years. We didn't learn about TSG's involvement in the case at all until around December 2018 or November 2018 when that complaint was amended. And then we didn't realize about the full scope of their involvement until January or February 2019. So again, counsel's essentially saying there might have been other avenues available. We could have done non-party discovery and maybe some of these things would have been uncovered, but that doesn't change the fact that discovery was not complete in the case prior to summary judgment being granted. And I don't believe that there's any lack of diligence.
You got 30 seconds, so go ahead.
I'm sorry.
You got 30, yeah, go ahead.
I was just going to say that as far as counsel's statement that the architect's testimony couldn't have impacted the viability of the causes of action, there's simply no way to know that because we don't know what the architect is going to testify to. We should have been permitted to complete that deposition, to review the discovery prior to summary judgment being granted. And we believe that there were genuine issues of material facts that precluded summary judgment. So we would respectfully request that this court reverse the decision of the trial court.
Perfect time. Okay. Thank you both very much. Very interesting case. Well argued, well briefed. Have a good day.